morning, everyone. I'm Michael Green, the Clerk of Green's List, and we welcome you this morning to our breakfast briefing with Peter Lovell speaking on the statutory requirements for lawyers' bills of legal costs, the topic dearest to the heart of all lawyers, or I guess getting paid is, so helping people to get paid. A couple of pieces of housekeeping. On the record for your CPD points, it says there's substantive law under field. In fact, it's not substantive law, it's probably practice management. So it's one of those three non-substantive law points. So maybe you might want to change that if you're going to keep this as a record of your CPD activities during the year. So practice management would be the correct category. Questions, of course, Peter's question is fine with questions. He'd prefer to do them at the end because there's a fair bit to get through before questions come along. So maybe if you want to save your questions till the end, that might be the smoothest way for the morning to run. A brief introduction of Peter. I think most of you would know Peter. Peter has got the grey hair to indicate that he's been in the law a long time. He has a commercial practice here at the bar, which over the years has developed into a significant part of that practice being legal costs. And I think without being biased in favour of one of our list members, I would say Peter's the leading expert at the bar in the area of legal costs. So he brings a lot of expertise and experience to his topic this morning. Please welcome Peter Lovell.
Thank you, Michael. In past seminars, I've spoken about cost agreements and compliance under the Legal Profession Act and also under the Uniform Law. I've spoken about costs, disclosure and cost estimates compliance. This particular seminar focuses only on the bill. So I just want to make that clear, since some of my early questions when I arrived this morning seem to relate to cost agreements. But you may need to go back to some of those past seminars if you wish to brush up on cost agreements.
And Peter, could I say they're on our website, the papers and a video will be on the website?
Okay, they're on the Greens List website. So I feature gloriously, apparently, on that website. How far do they go back?
As long as they're current, they remain on the website.
Excellent. Okay. Now, as you'll see from the preamble to this paper, and I emphasise it's an outline of statutory requirements because the devil is in the detail. The detail is in the footnote. The footnote takes you to a section. The section has numerous qualifications. So be very careful when you are applying what I've said here to a real-life situation. Most of you would be aware that we are now governed by the Uniform Law, as I call it. It is within the Legal Profession Uniform Law Application Act. This is that act. So the Uniform Law is an act within the act. It is a schedule to this particular act. So when you are quoting sections of the Uniform Law, do not say it's section such and such of the Legal Profession Uniform Law Application Act, because it isn't. You are referring to a different statute. It is described as the Legal Profession Uniform Law Victoria. That is its correct name. You can also refer to it as the Legal Profession Uniform Law. Don't call it the Legal Profession Uniform Law Act, which many practitioners seem to do. So this paper covers the requirements under that particular statute, and it also covers the requirements under the Legal Profession Act 2004. And I've explained why, because the Legal Profession Act 2004 still applies if your client's retainer commenced before the 1st of July 2015. A lot of practitioners seem to think, quite incorrectly, that from now on, or at least from 2015 onwards, everything falls under the Uniform Law. That is not the case. If your client knocked on your office door before the 1st of July 2015, you are still governed by the Legal Profession Act 2004. for these types of purposes. So I want to make that clear. Okay, let's get into the nitty-gritty under the heading A, requirement for a bill of legal costs. The legal cost to be billed must be fair and reasonable. And you might think, well, so what? Yeah, my costs are fair and reasonable. I normally get them to sign a cost agreement charging my usual $880 an hour, including GST. But that may not be reasonable in the context of the nature of the matter. It may not be reasonable in the context of the nature or the extent of your skill or the skill that needs to be applied to that particular matter. So penalties, as you'll see in footnote number 4, penalties may arise under section 207. Section 207, this is why I was referring earlier to devil in the detail. Section 207 takes you down a nice, neat pathway which you can't get off to sections 296, 297 and 298. And those sections then start wheeling out the guillotine where your hand gets chopped off for if you are found to have charged more than fair and reasonable costs. So have a close read of section 298, little d for Donald in brackets, when you get back to the office, and you'll see how many fingers you might lose in those circumstances. I'm not going to read through this entire paper, of course, but you'll see there legal costs includes disbursements. So when you are giving estimates, you need to factor that in. But it does not include interest, and of course it does not include GST in a strict sense because that's a tax. But various aspects of GST can be taken into account, but I don't want to dwell on that for the minute. Okay, I've said there in the last paragraph on the first page that generally speaking most law practices charge costs pursuant to a cost agreement. You don't have to have a cost agreement, but it's pretty much the way we're going these days. So you might have a particular hourly rate in your cost agreement. Your cost agreement might nevertheless adopt a particular court scale. So you can do that via a cost agreement. You might, for non-contentious matters, be adopting the practitioner remuneration order, the PRO, or you might have a hybrid situation which is usually a bit messy, but I'm not going to dwell on that today. So just make sure that your legal costs are not more than fair and reasonable. I might say that if your cost agreement does get torn up by the court and put in the bin, then the default position is that you fall back to, generally speaking, fall back to the applicable scale rates, or the PRO as the case may be. Okay, most of you would have known that anyway, but anyway, so moving on to the form of the bill, the format of the bill. Most of you would probably send out a lump sum bill, and you'll see there I've got an attachment A to this paper, which is a very short, typical lump sum bill. This is a lump sum bill that was drawn under the Legal Profession Act 2004, even though it's a later bill dated in 2015. This is what the cost court would see as a typical lump sum bill. The detail in the paragraph there, explaining what the work was done, can in other bills, in other firms, be quite lengthy. Might go for 2 or 3 pages, but it's still a lump sum bill. Even if you broke down that information or that detail into dates, it's still a lump sum bill. Okay. Some practitioners seem to think that giving more detail turns it into an itemised bill. So it might be a detailed bill, but it might not be an itemised bill for the purposes of the legislation. In my paper, I've explained that an itemised bill means a bill that specifies in detail how the costs are made up, and I've gone on about the Order 63 rules and what goes into an itemised bill. I'm not going to wax lyrical about that, but if you go to attachment B, this is a 3-page extract of a 7-page bill, and then normally it would have a cover page. It would actually be addressed to the client. I haven't bothered to photocopy that, but it's designed to give you an idea of how an item, or what an itemised bill looks like. You'll see that the itemised bill literally is an item by item, date by date chronology of the work that was done for the client by the solicitor. And you will see there on the first page of attachment B, there's a change of scale, because as you know, scales tend to change each year, and that's reflected in the itemised bill, and it goes on ad nauseum in excruciating detail. And some of these itemised bills could be, 100 pages long, 200 pages long, 300 pages long, amounting to many, many thousands of dollars. And of course, they cost a lot of money. They cost a lot of money to have drawn. If you go to a cost lawyer or a cost consultant, and the various individuals that tend to advertise at in the Law Institute Journal for performing these sorts of tasks. So that exhibit or attachment B is an itemised bill, and that's the sort of bill or sort of format of a bill that would be taxed or reviewed, to use a different word, or to use another different word, assessed, in the cost court. Taxation is the old-fashioned word. We tend to say bills are taxed in the cost court. Under the LPA 2004, it uses the word reviewed, because a lot of people, especially in party matters, used to think taxation had something to do with income tax. And now under the uniform law, the politicians tend to use the word assessed, but it all means the same thing. What is interesting is if you go to the attachment C, following a recent decision that I was involved in, you'll see it referred to in footnote 13. If you can have your finger on footnote 13 and attachment C, which is what we have to do when we're in court, have fingers in all sorts of pages. The decision of Small and Worcester against Piper Alderman, and also there was an appeal to the Court of Appeal, Piper Alderman against Small and Worcester, where this type of this is my language, I've described it as an informal itemised bill. It doesn't have the typical taxation paper with the fancy lines and all that type of thing. Excuse me. And you'll see there that it is the actual detail is broken up into date, fee earner, and the names are masked, of course, their position, their time, the time they spend on this particular item by item, their hourly rate and what that works out to in a value, and then they've given particulars on in the far right column. Now, the Court of Appeal in this case, for all sorts of reasons I won't go into, found that this was in fact an itemised bill. And so the relevant firm could not go away and freshly draw an itemised bill with a higher quantum of costs, which I'll come to later on in the paper actually. So I'm beginning to notice that some of the bigger firms in the city, and maybe there are some in the suburbs, are beginning to use this type of, I guess you could call it a ledger type printout, to effect their billing. And if their bills are challenged by a client and they need to be taxed, they do not have to go back and pull out 7 boxes of files and send them off to a cost consultant or a cost lawyer to have a a formal itemised bill drawn, they can produce this type of ledger printout on a day-by-day basis, and subject to some of the warnings by the Court of Appeal in the Piper Alderman case, you may find that you are in fact creating an itemised bill as you go. So that could be good and that could be bad, but I'll leave that up to you. The important aspect is that in the particulars in the far right-hand column of this informal itemised bill, you should take care not to have global entries. A global entry is where you might say for your 2.5 hours of work that you're claiming on a particular day, where you list a whole lot of things: emailing, drafting affidavit, looking at discovered documents, perusing this, perusing that, doing something else. That is a global entry, and the more global entries you have, the less likely it will be that the court will see this as an itemised bill. It may in fact be treated as a lump sum bill nevertheless. So heed the warning of the Court of Appeal in Piper Alderman against Small and Wooster. Okay, the signing of a bill. A bill must be signed, as you well know, on behalf of the law practice. Now, under the LPA, that's the 2004 legislation, that's, as I'll repeat again, if your client retained your firm before the 1st of July 2015, under the LPA, a legal practitioner or an employee of the law practice can sign the bill, and I've given some further detail there which I'm not going to read. But under the uniform law, the bill or a letter accompanying the bill must be signed by the so-called responsible principal. So, and your bill ought nominate in writing who the responsible principal is. If you do not do that, then every principal in your firm will be automatically the responsible principal. And as I've said in footnote 16, there's a definition of principal at section 6 of the Uniform Law, but there's no definition of a responsible principal, although it explains that everyone who is a principal of that firm will be captured, so to speak, if a responsible principal is not nominated in the bill or in the letter accompanying the bill. And later on, in fact on the next page, you'll see there a reference to attachment D, where I've taken the liberty of reproducing a warning produced by the Victorian Legal Services Board and Commissioner as to who a principal is and how apparently individuals undeserving of that title are using the word principal. So just read that warning carefully. But if you are a principal and you do not nominate yourself as responsible for the bill, then everyone else is automatically, in the firm that is automatically nominated. And importantly, as I've said at the top of page 3, this means that if the law practice is found to have charged more than fair and reasonable costs, and now coming back to that concept again, and if that is found to be capable of constituting unsatisfactory professional conduct or professional misconduct, I put those words in bold in italics because they're actually defined in the legislation, then every principal will be liable for disciplinary action, as well as each legal practitioner associate. Excuse me. And if you follow the arrows as to what a legal practitioner associate is, you will find that, as I've explained in footnote 19, it's a principal, partner, director, officer, employee, agent or consultant of the firm, but as long as they are legal practitioners, of course. So then everyone who's a lawyer can be captured and taken off to the guillotine for hand chopping purposes. Of course, if you go into the relevant section, section 207 and thereabouts of the Uniform Law, there are some opportunities to put your hand up and say why your hand should not be chopped off, but it's up to you to come up with an excuse. Okay. That's an important aspect, this responsible principle requirement, which I'm noticing in modern day bills is not being adhered to. Okay, next heading, notification of clients' rights about cost disputes. Now, most of you will be familiar that under the LPA 2004, a bill must include or be accompanied by a particular statement about the client's rights. And most of you or your firms would have that statement embedded in the bill, or it ought be in the accompanying letter when the bill is sent out. It's best, obviously, to have it embedded in the bill, because when you send the bill out and put the statement in a covering letter, then upon challenge of your legal costs, of course, the clients magically never got the letter. So make sure it's in the bill, because it's harder for the clients to suddenly claim that they didn't receive certain aspects of the paperwork, which surprisingly seems to be quite common when they're challenging solicitors' costs. The clients just don't seem to receive much at all, according to them. But anyway, even emails. So just be on guard about that. The Uniform Law, you'll see there at the second last paragraph on page 3, the Uniform Law makes similar provision, but there's not any LPA shortcut. I'm not going to dwell too much on the LPA shortcut. You can look it up yourselves. So it's best to have your own embedded warning in the bill, and I've attached an example of the embedded warning at attachment E. This is your typical embedded warning, and this is an example, or the attachment was actually page, or you can see from the top, page 5 of the actual bill. So you'll see there that that's the type of embedded notification of rights that you ought to have in your bill. I'm not going to take you through it all, but that is a compliant example of what's required under the Uniform Law. You can read that at your leisure and double check that your embedded warnings use this type of wording. It doesn't mean to say that your embedded warnings are incorrect, but this is a typical example. Okay. I'm not going to, I'll leave you to read the balance of page 3 at your leisure. Let's move on to interest. Interest on late payment of bill. Under the LPA, a law practice must charge interest on, or I should say may charge interest on unpaid legal costs if the bill's unpaid for 30 days or more. And the bill must contain a statement that late payment interest will be payable in the rate of the interest. I still come across statements in bills where the wrong interest rate is quoted. You'll see there in words in parenthesis, I've said some law practices still wrongly refer to the penalty interest rate under the Penalty Interest Rates Act 1983. That is not the case. It's the cash rate target of the Reserve Bank of Australia plus 2%. So just double check that your bill templates comply with that. In fact, I received a brief in a matter only a couple of days ago where the incorrect interest rate was stated. Okay, the Uniform Law makes similar provision, but save that interest cannot be charged on a bill that's given more than 6 months after completion of the matter. There are some exceptions there, but if you complete your matter and you sit on your hands and do not bother billing, I don't know why, but you do not bother billing for a year or two, then you cannot charge interest at all. Unless you come within those exceptions. The client may, for some odd reason, have asked you not to send the bill for a particular period of time. Okay. Itemised bill of a higher amount. This is a quirky provision in both statutes. Some of you, I know some people here are very well aware of the fact that if a client requests an itemised bill of costs after having received a lump sum bill, then the itemised bill may be higher than the lump sum bill. That is permitted under the Legal Profession Act 2004. A typical situation, how that arises, is where somebody in the law firm does, let's say, a year's worth of work. They might have sent off 2 or 3 interim bills and then they send a final bill. The total of those bills, let's say, come to $95,000. The client kicks up a fuss, thinks the amounts are too high, and turns around and says, I want an itemised bill. I'm going to have these costs assessed. You, the law firm, send off your box of files to a cost lawyer, and the cost lawyer draws an itemised bill in correct format, and it comes in at $157,000. You have the benefit of that excess. It's still subject to being taxed in the cost court, or assessed or reviewed in the cost court. So that $157,000 could be taxed down, but it might be taxed down to $135,000. So the client's no better off, in fact worse off. That is a possibility, and that type of thing can happen from time to time. Now that is the situation which arises under the Legal Profession Act 2004. Under the Uniform Law Act, here I am making a mistake myself, under the Uniform Law, that is still a possibility, but your lump sum bill has to give the warning up front to the client. So when you send your lump sum bill to the client, you need to have an embedded warning that if the client seeks an itemised bill, then there is that possible outcome. And if you go to, attachment E again, attachment E, that's the very last page of the handout, I think, you'll see that warning in paragraph 2 of the embedded notification of rights, and it goes on to say quite correctly, request an itemised bill, you must do this within 30 days, etc., etc. We'll provide an itemised bill at no charge. However, if you request an itemised bill and the total amount specified in the itemised bill exceeds the amount previously specified in the lump sum bill for the same matter, then we may be able to recover the higher costs, etc., etc., etc. That is the requirement under section 187 of the Uniform Law. So that paragraph 2 of this particular example of an embedded notification of rights is in compliance with section 187 of the Uniform Law. So that's the sort of thing you need to do if you are billing a client for a matter which is where the retainer comes under the Uniform Law. That is a retainer after the 1st of July 2015. Okay. Charging for bills. You might think, oh, well, of course we don't charge for bills. But I can tell you I have seen on many occasions charges for bills, particularly in itemised bills, or where the relevant law firm has tried to create their own itemised bill for taxing purposes. You cannot charge for the cost agreement side of things, you cannot charge for cost estimate side of things, and you cannot charge for bills. And in fact, to make it absolutely clear, under the uniform law, a law practice must not make a charge for preparing or giving a bill. There is a qualification I've put in there on the last sentence of that section, where on the completion of a cost review or cost assessment in the cost court, it can, for the drawing of the bill and providing a copy of the bill, etc., can be claimed on a folio basis as part of the costs of the taxation, because clearly you can't have a taxation of costs without an itemised bill. So if you read the qualification in footnote 34, I've explained how that can come about, subject to various contingencies, etc. Okay, delivery of a bill. Under the LPA, a bill may be given to the client by personal delivery, post and so on. It curiously goes on to say, and these words in quotes are actually in the legislation, or by leaving it with a person who is apparently over 16 years old and, it's not or, and apparently employed or residing there. So if there's any doubt, if you give it to someone that looks like they're 16 or could be 15 and maybe they're visiting from across the road, then you may need affidavit evidence as to how that bill was delivered. But normally that would be a very rare situation. A bill may, and this is still under the LPA, a bill may not be given electronically, that is by email. I don't know how many of you still send bills by email, unless the client is a sophisticated client. Now, there's actually a definition, obviously, in the LPA as to what a sophisticated client is. A sophisticated client is not a person that lives in Brighton. A sophisticated client...
Be careful, Peter.
A sophisticated client has a particular definition. It's another lawyer, for example. It's a public company, for example. It's a subsidiary of a public company. It's a large proprietary company. It's a receiver, manager, that type of thing. They come under the definition of sophisticated client in the LPA. The same situation applies under the uniform law, except the expression sophisticated client created so much confusion in the minds of the clients themselves that the definition is now, or the title of the definition is now described as a commercial or government client. So when you come across commercial or government client in uniform law, that's the same thing as a sophisticated client under the LPA. And generally speaking, if you look at the types of entities that are captured by those definitions, they're entities that are meant to understand costs, understand bills of costs and understand what's going on, or at least have legal advisors to explain to them what it's all about. So there are some exceptions to these requirements for a sophisticated client or in the modern day commercial government client. Anyway, under the uniform law, a bill may be given perhaps happily to DX addresses by fax to a fax number specified by the client. Now, don't just fax the bill off to the client. it says specifically if the client has consented to receive bills by fax. The uniform law is now very, very detailed. So a lot of these things where you just think, oh, we can email now, oh, we can fax now, you need the client's consent to do that. So even sending by email, etc., electronically to an email address or to a mobile phone number, sort of thing my kids would do to me. You only communicate with people by phone, SMS, etc., as specified by the client, if the client has so consented, and so on and so forth. And of course, you may serve a bill akin to any other document by way of service if you were wanting to go to those lengths. Importantly, and this has come up in a recent matter where the result was not favourable to the law firm, if you are delivering a bill to persons who are jointly or jointly and severally liable, then delivery ought to be made to each person. It's not enough to have the particular joint or joint and several clients just simply named on the bill, in the address that is, and send that bill to one of those people only. So you need to make sure that the bill goes to each person that is jointly and severally liable. Okay. Recovering payment of a bill by legal proceedings. Again, there's a difference between the LPA and the uniform law. Under the LPA, you must not commence legal proceedings to recover legal costs until at least 65 days after the bill has been given. And it has to be a bill given in accordance with those sections I've mentioned there, 3.4.34 and 3.4.35. They're the sections that say a bill must have the embedded notification of rights, a bill must be signed, and so on and so forth. So you need to have a compliant bill, and you need to patiently wait at least 65 days after giving the bill before you can sue. Again, it amazes me, quite frankly, how many firms sue within the 65-day period and then they're in a mess straight away. But so please put your stopwatch on and patiently wait the 65 days before you sue, if that's what you wish to do. And you'll see there that the relevant court can immediately stay the proceedings if you have preemptively sued before the 65-day period. The deadline for suing under the uniform law is different. It's actually, in one sense, it could be shorter, but it probably isn't, because you cannot sue until at least 30 days after the later of the date on which the client is given a bill, or the date on which the client receives an itemised bill following a request for one. So you might have a situation where you're in a position where you're about to sue, but the client then says, well, I'm on an itemised bill. So you need to be careful as to whether you, to ensure that you don't jump the gun in suing in those circumstances. I've also said there in the last paragraph, last sentence of that section, if there is an extant cost dispute before the Legal Services Board, then you cannot maintain proceedings until that dispute has actually been closed or resolved. So a lot of this is fairly straightforward, but you need to be conscious of the fact that the uniform law now has different deadlines, different requirements, different consent requirements, and so on and so forth. So let's get down to the nitty-gritty of what this paper's all about. Is a compliant lump sum bill payable at all? And I've said there, prima facie, yes, let's assume we've got the perfect bill, as in format, compliance, responsible principal and so on. But these bullet points throw up the sort of situations that I come across from time to time. The bill's been sent to the wrong person. It's been sent to the director instead of the company. It turns out that there's been some enormous confusion about, after the event I might say, about who the client actually is. In fact, about a year ago, I had a matter in the cross court where we had cross-examination for 4 days about who the client actually was, whether it was this company or another company or another company or another company, all of which had similar names. And at the end of the day, the law firm or the relevant person at the law firm did not have a clue. Didn't even know who the client was. So please be sure, or to ensure, that you are dealing with the person who is the client, and or you are dealing with the person who is going to be liable to pay the costs, if not the client, a third-party payer. That can be sorted out in the first or second meeting when the substantive matter commences. Also, and similarly, second bullet point, the bill's been sent to the wrong corporate entity, so that what I've already said covers that as well. Make sure you're dealing with the correct corporate entity. Third bullet point, that the law firm has sent the bill to a person in the mistaken belief that the person is joint and severally liable when they're not. So please be careful about who you're dealing with, whether other parties are to be jointly and severally liable. For example, are you acting for the company and the director? Or are you acting for the company and simply receiving instructions on behalf of the company from the director? So that is something you need to be on guard about. You might be sending a bill, this is the fourth bullet point, to a person in mistaken belief that the person is a third-party payer when the person is not a third-party payer. If you go to section 171 of the Uniform Law, that's in the footnote in any event, it will give you definitions of what a third-party payer is. A third-party payer might be an associated third-party payer where that person or entity is liable to pay legal costs directly to the firm, or it might be a non-associated third-party payer where that person is liable to pay the costs to the client, who then is liable to pay the cost to the firm. So these are all little quirky things that you need to apply your mind to early in the retainer, day one of the retainer. And you need to make sure that your cost agreement reflects these sorts of situations. And if you're having, for example, somebody being the guarantor of the payment of costs by the client, that's all wrapped up in the cost agreement, third-party payer, etc., etc. The next bullet point, you might be sending a bill to a person in the mistaken belief that the billed legal costs were provided pursuant to the retainer. This is an interesting one because if you look at the footnoted case there, the relevant lawyer billed the client for work that he had done, and the client said, "But I didn't want this work to be done. This was not the work I retained the client to perform on my behalf," and the client was successful. If you look specifically at section 1, and I've not mentioned this in the footnote, but if you, in relation to the same bullet point, if you make a note of the Uniform Law section 172, I'll just look it up. 172, subsection 2, little f for Freddie. Section 172 talks about how legal costs must be fair and reasonable, but that subparagraph F says, and I'll short circuit this, in considering whether legal costs satisfies subsection 1, that's about fair and reasonable costs, regard must be had to whether the legal costs reasonably reflect, and it goes A, B, C, D, all the way down to F, and little f for Freddie says the retainer and the instructions given in the matter. So you need to ensure that you are in fact billing for instructions given in the matter, not billing for things that you thought you ought to just to be on the safe side, and it turns out the client didn't give you those relevant instructions. Even if your bill, even if you couldn't recover the entire amount in your bill, you might find that on a taxation of costs or a review of costs, that a significant portion of your billed work might be taxed off or reduced, as the case may be. And the final bullet point is that your perfectly formatted bill might be in relation to claiming costs under a cost agreement when your cost agreement is going to be, is in fact void. Because under the uniform law, which in my opinion is quite draconian, and I know some higher beings don't like me using that word draconian, so I'll try not to use the word draconian. But if you think the uniform law is draconian, then if you do not comply with cost estimates and cost compliance requirements, your beautiful, let's say perfect cost agreement is immediately rendered void, automatically rendered void. And as I said earlier, the default position is the applicable scale rates and so on and so forth. So you might find that your bill of costs is not payable on that basis. Okay. So things aren't always as clear as they seem. I've said at the top of page 7 that you can probably resurrect the situation by sending a compliant bill to the correct person, etc., etc., etc. But you would have wasted a lot of costs in getting to that position if you sued the wrong person. Then in the next section is a non-compliant lump sum bill of costs payable at all. Now here, when I say non-compliant, I'm focusing on a bill which does not have the embedded notification of rights, hasn't been signed by the responsible principal and so on. But assuming you do send the bill to the correct person and it is on the correct rates and it is for the provision of correctly retained legal services, but it is non-compliant in format, then it might be valid for some purposes but not for other purposes. Now, I need to distinguish or have you understand the difference between a bill being reviewed in the cost court and a bill being sued for by you in a court of law. So I've said here first, the bill will be valid to the extent that a client or third party payer will have the right to apply for a cost review. So your non-compliant bill, albeit sent to the correct person, etc., is still valid for the purpose of a client challenging your costs, reviewing your costs, and having those costs assessed. So if you digest that paragraph commencing with the word first, at your leisure, I don't mean right now, then you might find that it is challengeable. And I've said here in halfway down, I've said, however, as noted above under the uniform rules, if the total amount of any itemised bill exceeds the amount of the earlier lump sum bill for the same matter, then any additional costs are not recoverable if the bill failed to disclose and reserve to the law practice that possible outcome. And that was that warning I gave you before, in which you can look at attachment E, paragraph 2. Secondly, a non-compliant bill under the LPA may nevertheless be treated as a final bill for the purpose of determining whether a client's application for cost review is made within time. Under the LPA and also under the uniform law, a client has 12 months to apply to challenge your costs. Now, and I've given an example there, if you send a non-compliant bill to the client and then you later on send the a compliant bill to replace it in effect, the 12-month period runs from the date of the earlier bill, so that can actually work in your favour to some degree. And I've referred there to the relevant cases in footnote 51. But this, so far, all I have explained in these few paragraphs is that you cannot shut out a client from reviewing costs because your bill is non-compliant. But, and importantly, when you get to the word thirdly at the bottom of page 7, under the LPA it appears that a non-compliant bill will not support a recovery proceeding brought in a court. So this is where you are actually suing, let's say in the magistrate's court or the county court, on your bill. And I've quoted on the next page findings or rulings of Her Honour Justice Ferguson, where this very issue arose. And Her Honour distinguished between a bill for cost review purposes and a bill for recovery purposes. Excuse me. And Her Honour says, I do not accept the contention that because the entitlement to recover costs is dependent on a bill with any relevant disclosures being given, it must follow that the proper construction of section 3438.5, that's the review side of things in the LPA, so she's talking about review at this stage, is that a bill must always be given before time starts to run, seeking a review of costs. The right to recovery and the right to review are separate matters. Whether the time period which must elapse before bringing proceedings has passed does not affect whether the time limit seeking a review has expired. And then this, Her Honour goes on to say, importantly, in my opinion, moreover, whilst the failure to make disclosure as to avenues open in the event of dispute about costs has certain consequences, including that the law practice must not commence recovery proceedings, it does not prevent time from running for seeking a cost review. And I have found in my dealings with lawyers from time to time there is often confusion between review rights and recovery rights. Similarly, I found, I just might, as a by the by, find that lawyers do not understand there is a distinction between cost agreement and cost disclosure, but that's the subject of prior seminars. And then I've said, fourthly, even if a law practice could commence a recovery proceeding based on a non-compliant bill, the client can, in effect, have that stayed. And I've explained why in footnote 53. Okay. And finally, this section E touches a little on non-compliance cost disclosure. I've said that, as I've said at the beginning, this seminar paper is not designed to discuss agreements and disclosure requirements. It's more to do with bills. But because the draconian effect, sorry for using that word, of section 178(1) means that non-compliant cost disclosure will have your cost agreement burst into flames, The uniform rules were amended last year to disapply, unusual word, the disapplication of section 178, 1 and 2 in certain circumstances. So if you took reasonable steps to comply with cost disclosure obligations, but you didn't quite get there properly, and when you discover that you didn't quite get there properly, you within 14 days try and rectify the situation as far as practicable, and the contravention, your contravention was not substantial, and it would not be reasonable to expect that the client would have made different decisions in relation to the relevant aspect, then you might then be able to rescue your cost agreement and seek payment of any unpaid legal costs based on the rates in the cost agreement, and avoid prosecution for unsatisfactory professional conduct and professional misconduct. Okay. So just digest that. I know I've raced through this and there are a lot of footnotes and whatnot. So as I've said in my conclusion, please take close care in drawing, signing and delivering any lump sum interim or itemised bill, and do not assume, as some of my instructors have, that your firm's billing templates, these are the templates you have on your computer system, are compliant under both the LPA and the uniform law. So some templates might have an embedded warning for LPA matters, and you might have a separate bill with an embedded warning for uniform law matters. Some firms have them both in the bill, where they say if your retainer commenced before the 1st of July and if your retainer commenced after, etc., these apply. So please take all this on board. I know, I guess, bills of costs are taken for granted, but I felt obliged to give this seminar because of what I see in the cost court. Thank you.
Questions, Peter? I'm just going to grab a microphone here.
Thank you, Peter. In relation to one of the last points that you made under section E, in relation to being able to have the section not applied, what would be the avenue or venue for what are effectively fact-based matters? Where would you air those things that you took reasonable steps? Would it be in front of the cost court?
No. What usually happens is if it comes to let's say it comes to your attention, you immediately write to the client. It's not to the cost court. It's the cost court situation might arise in 6 months' time. Or it might be, you might have discovered the contravention because the client is beginning to challenge costs, and often when clients challenge costs, they've gone to another firm. So what happens is your lovely client becomes aggrieved, they then go to another firm, then the other firm writes to you and saying, how dare you, how dare you, how dare you. If any of those contraventions can be corrected, you need, and assuming that's the first time you've found out about it, and assuming, don't forget it's the first bullet point, assuming you initially took reasonable steps to comply with the disclosure obligation. So you had to have tried to do something. You can't do nothing and then when you're attacked by the former client's new solicitor to then say, oh, okay, here it all is now. So it has to be a relatively not substantial contravention.
But that's what I mean. So if you've done that in the course of the matter,
yes,
and then at some point there's a challenge, I suppose in the challenge you should be able to bring evidence of those.
Oh, absolutely, absolutely.
You mentioned one of them was who your client is. So in the case of the company, not giving it to the director or to the director. In the case of a small company, say, to whom should you address your bill?
The way I would answer that question is what are you retained to do and who are you doing it for? So, for instance, if you are acting or retained by a company to, let's say, prevent the company from being wound up, and the company is the client, and the director in conference with you has said, by the way, the company is the client, or better still, you say to the director, are you paying the costs or is the company paying the costs? Clearly, you might conclude, I'm acting for the company. Is the company going to be liable for the costs, or are you going to be liable for the costs? So the company can be the client and the director can be the third-party payer, for instance, where the third-party payer, i.e. the director, is liable to pay the cost directly to your firm for the work you're doing on behalf of the company. But I think it's important, and I get the feeling this isn't done too often, or perhaps not as often as it should be, you need to put the asset on the client or on the person that's sitting opposite you to clarify these issues and to put it in the cost agreement and to make it clear to your level that you are acting for this party. Because what happens if there's a challenge in the cost court, as in the example I gave you before, where there was 4 days of cross-examination where my own instructor didn't even know who the client was. He thought he knew who the client was, but it turned out after very embarrassing cross-examination, I might say, he had no idea. So you don't want to get into that mess. So just sit down and put the asset on the client, work it out, and write, confirmed in writing, send it off with a cost agreement, etc., etc. That's what I'd say.
So to clarify then, in that example you gave where the company may be wound up, you shouldn't. I mean, that's an alarm bell where you should.
Yeah.
Say, we take instructions on behalf of the company, but you as the director are personally liable for the cost.
Yeah.
So you cover that.
We will act for you.
Should you still address the
Yeah, we will act for you if. Simple as that. You might want a guarantee from some other directors. You might want security over property. You can take security over property for your legal costs. But put the asset on. Don't be meek and mild about it. That's my view.
In relation to that last point, if in your costs agreement the parties, apart from the further, let's say it's a privately small company, the company and the main director, John Smith, wouldn't that be evidence that both parties are your clients in that particular matter?
It would be, particularly if you manage to get them to sign it. Don't forget a lot of cost agreements come back unsigned. I'm not talking about conditional cost agreements because they have to be signed, but the same problems arise if you send off a cost agreement and say, this cost agreement is deemed to be accepted by the provision of further instructions and etc., and they come back unsigned. The chances are you might get over the line in demonstrating that they're both clients, but it's still arguable, in my opinion. I would prefer to have the cost agreement signed.
If it's signed by both of those parties, the company and the director.
Director on behalf of company, director for himself.
Yes.
Simple as that. Yeah. Don't be meek and mild about it.
Thank you.
Sometimes we apply a discount to a tax invoice. If that was subsequently to be costed, would we be able, and it was a higher amount, would we be able to recover that discount?
The answer is yes, but it depends how the discounts come about. If it's an accord and satisfaction arrangement where you are actually giving it, where let's say there's been a dispute about the costs, and you say, okay, we will take 30,000 instead of 50, and you've signed some sort of an agreement, then that pretty much closes it out. But if you are just saying 25,000 but say 22, then that's fine.
Yeah. Can I just have one other question, if I could? In the joint and several one, if we're acting for Mr. and Mrs. Smith with the same address, should we be posting the tax invoice to them separately?
Well, not in that case.
Thank you.
I was contemplating situations where you had people that are distinctly different entities, different addresses, that type of thing. You might be acting for 3 co-defendants, for instance, for various reasons, where rather than being separately represented, it would be sensible for them to be represented by the same firm because they have common interests, especially beneficiaries of a trust or something like that. And they could even be living in different locations. Yeah.
Peter, recently in a Cost Court decision under the uniform law, it was a matter, I think it was called Jasmine, but I'm not 100% sure, it became clear that commercial and government clients didn't have the right to have their costs assessed at the Cost Court. And one of the issues was that the notification of rights was a standard notification of rights that indicated that that was a possibility. And the Cost Court, from my understanding, said that it could be misleading for commercial clients if you include a notification that tells them they have rights that they don't have. And I thought it was an interesting, it was news to me. And I think it's an interesting point to make that if you are acting for commercial clients under the uniform law, that your notification of rights has to say, unless you are a government or commercial client. Have you had experience?
Not under the uniform law, but the matter I was talking about before, including the 4 days of cross-examination, was under the LPA, where a similar situation arose. And it was found in that particular case that the law firm had inadvertently tried to give notification of rights, tried to give cost disclosure, etc., when it was unnecessary, but having done it, were then held to be required to keep doing it, which they didn't do. So, but I'm not familiar with the case you're talking about. So
that particular case, in the end, they got to the taxation or assessment, and suddenly, I think it was, I can't remember, it was one of the parties went, oh, no jurisdiction, and then it was on for young and old. And the Cost Court were very critical of all the parties who had engaged actively in getting it there, and then someone went, oh, no jurisdiction, and the Cost Court let them have it, basically. Everybody went away with their bottoms spanked. And, yeah, so,
Okay.
But it's interesting if you are acting for commercial clients not to have them, to have your notification of rights basically say, unless you are a commercial client.
absolutely,
Yeah.
absolutely. I'd agree with that.
Yeah.
Any more questions?
Also.
I think, Peter, you just about cleared out the room with a very erudite and even interesting presentation. Thank you on bills of cost. So please join me in thanking Peter Lovell.